Welcome back. For those of you who are not from this area, I hope you all got a chance to go outside, enjoy the sunshine and the warm weather of northern Ohio in January. My name is Mel Derschlag, and it is my honor and pleasure to introduce our keynote speaker for today. An old friend, or probably should say is friend of long standing, Professor Gene Nickel, or Nick as he's known to his friends and colleagues. Currently, Professor Nickel is a professor of law and director of the Center for Poverty, Work, and Opportunity at the University of North Carolina Law School in Chapel Hill. Gene did his undergraduate work at Oklahoma State, graduating in 1973 with a degree of in philosophy. For those of you who want to add something to your trivia bag, his mentor in the philosophy department was a young philosophy professor by the name of Ed Lowry. Now, that name doesn't mean anything to a lot of people, except for people who have an association with Case, because Ed Lowry is the younger brother of our friend and colleague Bob Lowry, who teaches at the law school. And so, for those of you who are associated here, this is it's a small world. I should mention that Professor Nickel was also the starting quarterback for the University for Oklahoma State Cowboys. But he went on from there, graduating from the University of Texas Law School in 1976, where he was elected to the Order of the Coif. Professor Nickel has had an extraordinary career as a teacher, as an administrator, as a scholar, certainly, and as a public servant. I first met Nick 20 years ago or more, in the mid-'80s, when he was the James Gould Cutler Professor of Law and Director of the Institute of the Bill of Rights at William and Mary Law School. He left William and Mary in 1988 to become the dean at the University of Colorado, where he also founded the Byron White Center for Constitutional Law in 1990. 1999, Professor Nickel left Colorado to become the dean and the Burton Craig Professor of Law at the University of North Carolina, and where in 2001 he founded the Center for Civil Rights. Professor Nickel left North Carolina in 2005 to return to William and Mary, but this time as president of William and Mary, where he remained until 2008. And then he returned to the University of North Carolina, where he currently is. We could spend the rest of the day, I think, recounting Professor Nickel's publications and the influence which those publications have had on the Academy. Suffice it to say that his articles have appeared in Harvard, Penn, Michigan, where his latest piece, I understand, is going to be published soon, Yale, Chicago, Berkeley, Duke, Virginia, the list goes on. He is also the co-author with Marty Reddish of Northwestern of the Federal Courts casebook, and a contributing author to another book entitled Where We Stand, Voices of Southern Dissent. We are truly honored to have him here to speak about the Roberts Court and access to justice. Professor G. Nickell. Nick.
Thank you, Mel. That is very kind, overly kind. It is, you know, when you're as old as I am and then you get introduced and they talk about all the places where you've been and what you've done, it creates an overwhelming sense that this character can't keep a job and kind of moves from venue to venue, and there is some truth in that in my case. And then Mel was right to say that I played football at Oklahoma State, and I was a philosophy major at Oklahoma State. If you think about this for just a second, I had two very distinct sets of friends at OSU. One group who averaged about 295 pounds apiece, and in some sense were not as thoughtful as some others. The second group, most of whom was from New Delhi, and weighed about 84 pounds. I tried to get them together, but it rarely worked. I'm just off a stint, which Mel skipped over very generously, I think, as a university president. It's part of the reason that I'm glad to be here. I may be the only person in the world who actually misses talking to lawyers, so I like the company. I was surprised, though only a little. Jonathan spoke this morning about the dean being off doing the things that deans do. I was surprised as a university president how often, rather than speaking on at least substantive topics like today, the job of a university president calls for what I refer to as the delivery of warm and mindless remarks, which are meant, of course, to kind of tap the affections of various people affiliated with the institution, warm the hearts of the alumni, loosen up their pocketbooks, one hopes, and never to offend. I was surprised how big a part of the job of university president the giving of warm and mindless remarks turned out to be. I was even more surprised when my colleagues started telling me almost uniformly that I'm actually very good at giving warm and mindless remarks. I am something of a natural at it. So I will here, after a little bit, depart from what are apparently my stronger talents. But if halfway through I forget myself and start asking you for money, please forgive me. These old habits die hard. It is great to see, it's great to be at Case, to see old friends from a number of sort of corners of my life. Our colleagues here, Mel and Jonathan. Linda Mullinex, also a Texan now. Rick Hills, who you heard from this morning, who when I was dean of the law school at Colorado was a very young boy doing work in Boulder. And I know that I told at least half the people in the American Legal Academy that this guy was going to be one of the most brilliant law professors that we will see in a generation, and it turned out, my predictions are usually shit, Rick, but it turned out that I was spot on in this one venture. I also I would say a word. I talked to Gary Simpson a couple days ago, and he said that he couldn't be here. But when I think about former colleagues and mentors, I am moved to mention your former dean, Gary Simpson, who was my teacher in law school. Now, as old as I am, I think it's probably fair to say he must have been a baby when he began this. And I don't know if Gary knows it, but he's actually responsible for me becoming an academic. I wrote a paper in his class that he literally almost forced me to get published which I clearly would not have done on my own. And since back then, hard to believe, but I was too bullheaded to do law review. I wasn't as sort of thoughtful and congenial as you folks are. If I hadn't published that article, I never would have gotten a job in the Academy, the University of Texas. No offense, but it's hardly a feeder school for this line of work. There have been a few times in the last 2 years when I have thought about getting me into the Academy, and I've been quite bitter about it. But I have always had an affection for Dean Simpson. If I could describe to you sitting in his class in 1976, I was a former football player from Oklahoma State University with hair down his back, who most days, this is stunning, but most days dressed only in overalls. It is horrifying to think about. I am certain that no other professor in the American Academy would have spoken to me, and they would have been justified in that conclusion. So I've always been grateful to Gary. Like everybody else, I enjoy getting to come to Cleveland. I thought the Cavs would do a little better last night than they did. And it's my theory that I may be the only person outside of Ohio who seriously considered voting for Dennis Kucinich. That was true until he did the spaceship business, and that was kind of more than I could go with. But frankly, anyone who believes that Major League is the greatest American film and that Randy Newman's Burn On Big River is the closest that we've ever come to true classical music, you are thrilled to come to Cleveland. I also clerked here for Squire Sanders and Dempsey after my second year, living for the summer in a third-floor, unair-conditioned walk-up in East Cleveland. Despite the weather today, it was then that I learned that Cleveland is a good deal hotter than Austin, Texas in the middle of the summer. And it was about the same time that the United States Supreme Court decided my favorite case, Moore against the city of East Cleveland. I had always understood why Mrs. Moore wanted to be able to live in the same house with her 2 grandkids. But after that summer, I never understood why she wanted to do it in East Cleveland. I do have a topic you'll be glad to hear, as do we all, the Roberts Court and access to justice. Not a simple one, not a narrow one, not, I think, uniform, not single-minded, not unimportant, not good, I started to say, but I'll hold off on that for just a minute. Thinking about access for this court and for its predecessors includes much, a ton of issues, even well beyond the long list that we'll discuss today. It explores, of course, the traditional tools of access, standing, mootness, ripeness, political questions, the congressional bestowal and stripping of jurisdiction, the expansion of the 11th Amendment and other immunities, the continued dwindling of the traditional writ of habeas corpus, both statutorily and through judicial crankiness, the state procedural default rules discussed this morning, the increased reluctance to hear facial and vagueness challenges to statutory regimes. But it moves, of course, beyond that as well, beyond concepts of jurisdiction, to broaden standards of federal preemption, which we heard discussed so thoroughly and helpfully this morning, to tighten statutes or notions of limitation, to new restrictions on the availability of punitive damages, decisions that have led many, including the Kiplinger Business Report, the Wall Street Journal, and Erwin Chemerinsky, those 3 brothers in the bond, to tag this court as decidedly pro-business. A portrait of access would also turn to narrowed doors for implied statutory causes of action, to similar sentiments apparent in Bivens cases, arguing in Bivens cases that they are a relic of the heady days in which the court assumed common law powers to create causes of action, a relic, the argument goes, that should be interred. I have at least one friend, a trier of civil rights cases, who claims that the most worrisome limitation on judicial access of the past 2.5 decades is the dramatically altered availability of summary judgment in Section 1983 cases with the resulting foreclosure of rights of jury trial. A portrait of the Roberts Court and access should include as well Bowles against Russell, which I mention particularly because Bill Marshall is here, former Case Western law professor, former Solicitor General of Ohio, former guitar player at the Barking Spider, and sadly for him, my best friend. Marshall, who was the lawyer before the United States Supreme Court in Bowles, where the court, pursuant to his compelling requests, ruled that a criminal defendant lost his right to appeal because his lawyer relied on a judge's order to file within 17 days instead of 14, as called for by the statute. The judge had mistakenly included the weekend in setting the deadline, but set the deadline he did. After Professor Marshall's argument, the Roberts Court concluded that rules are rules, and no flexibility should be offered in response to such a bait-and-switch routine. A case that one pundit described as, quote, a blow to anyone who puts faith in the promises of the judicial system, and another, quite distinguished, labeled simply mean, enforcing a strict letter of the law without any conceivable benefit, like something out of a Dickens novel or perhaps even Kafka. I rarely approve of such hysterical commentary, though it does in this instance seem warranted. It is delicious, though, that Bill, the great liberal constitutionalist, will now go down in history as a heartless closer of the federal doors. I myself have long thought of Marshall as Kafkaesque, though I could never decide whether he reminds me more of Joseph K. or the lead character in The Metamorphosis. Ouch. The just beginning to unfold legacy of the Roberts Court and access cannot be illustrated only by door-closing ventures. Though the newest appointees have usually dissented, the High Court's recent detainee decisions break remarkable ground in the assurance of a federal judicial forum. Boumediene against Bush is a surprising, and by my lights, courageous decision for this or any tribunal. Not only did the court invalidate a statute under the habeas corpus clause and rule against two branches of government acting in concert under claims of national security and prevent an explicit and unequivocal effort to restrict the jurisdiction of the federal courts, but it has been argued it offered, quote, the most aggressive exercise of judicial review of wartime measures adopted by the political branches in our nation's history, argued by one in this room. Boumediene is neither timid nor exclusionary. And few modern constitutional law decisions open the courthouse doors more generously and more enthusiastically than District of Columbia against Heller, last summer's handgun case. Until then, as Justice Stevens indicated, it had been understood that legislatures could regulate the civilian use of firearms so long as they did not interfere with the preservation of, as the term goes, a well-regulated militia. The Roberts majority decidedly upset that settled understanding while leaving to future cases, quote, the formidable task of defining the scope of permissible regulation. The Heller opinion speaks in sweeping terms, reminding that any balancing of interest required had already been accomplished in 1791 by the people. Alan Morrison may be right that under Heller, we're in for a round of lawyers' full employment, though I'm guessing it's not to be listed as part of any federal stimulus package. But reportedly, the NRA has already launched, and the justices are seemingly unconcerned about a stunning absence of expertise to venture so boldly into an arena. So it's possible to see the Roberts Court and Access and their commitment to it from different and varied vantage points, as reflecting different levels of consistency and commitment. I suppose it's not unlikely or surprising that, speaking broadly, scholars like Kathleen Sullivan would declare what we actually have is a pretty bold conservative agenda clothed in the gentle language of traditional modesty and restraint, or that the Wall Street Journal would enthuse that the biggest change under Chief Justice Roberts might not involve who wins on the merits, but rather who gets through the courthouse door in the first place. Like the Berger and Rehnquist courts before it, the Roberts Tribunal seems to show greater zest for limiting the forms, remedies, and processes of constitutional adjudication than in reversing the bold strokes of its predecessors on the merits. This is, after all, mere lawyers' work, hardly the stuff of major headlines and pointed political campaigns, though Lilly Ledbetter has proved the exception to that generally accurate rule. But the predilection for process is why, to wildly overgeneralize, constitutional law casebooks seem like something of a mishmash of stutter steps, expanding and contracting constitutional accountability, while federal courts books deliver more of a forced march across a broad array of fronts, with decisions pointedly opening the federal forum in the 60s and early 70s, followed by a cascade of decisions later in the 70s, and then again in the 80s and the 90s, and now, seeming to take away much of what had been given before. I add only two brief points before turning, as advertised, because someone has to do it, to the underappreciated wonders of the case or controversy requirement. The first is that as we explore throughout this day the multiple dimensions of the Roberts Court's treatment of access, it might be well to remind ourselves of what we inevitably leave out. Any discussion of access to our judicial system with a thoughtful visitor from a distant culture or climate would surely begin with our strongest transgression against access and equality, the exclusion of the voluntary use of the civil justice system of that huge portion of the population who cannot afford to pay the fare. Not to put too fine a point on it, but we carve equal justice under law on our courthouse walls. For decades, we have announced as our fundamental principle of constitutive adjudication that there can be no justice when the kind of trial a person gets depends upon the amount of money that he has. Yet study after study shows that at least 80% of the legal need of the poor in this country is unmet, and the circumstance is almost as bleak for middle-income Americans. What passes for civil justice among the have-nots is breathtaking. It cannot be counted, actually, as a system of justice. Yet the inequity does not provoke the attentions of the court that sits atop its structures, nor, too frequently, does it make it to the core of curricula and research in the legal academy that we love. For that, it is hard to find excuse. Second, having just returned from a cold 20th of January trip to the nation's capital, one of the most important things to be said about access to justice and a Roberts Court, apart from my prediction that our ever-confident Chief Justice will use a cheat sheet in 2013, or else turn over the duties to Justice Stevens, who will by then be 109. But the most interesting thing that can be said about a Roberts Court and access may well be that there won't really be one. That is, there won't be a Roberts Court. The High Court of the next decade may well bear the Chief Justice's name, but it will be a good deal less likely to profoundly bear the marks of his predilections. An Obama presidency, whatever else it might do, will not add to a Roberts, Alito, Scalia ascendancy. I'm not sure it's fair to characterize this court as, quote, the most conservative since the mid-1930s with Chemerinsky, or an unbreakable phalanx of conservatives with Dworkin, or the court conservatives have longed for and liberals feared with Linda Greenhouse, or the return of the Four Horsemen with Jonathan Turley, or even to say, as Justice Breyer did a year and a half ago, it is not often in law that so few have so quickly changed so much. Nor am I certain, as has often been asserted, that a studied agenda, traceable to earlier stints in the Meese Justice Department, drives Roberts Court decision-making. An agenda described as, quote, largely unchanged in the decades since. Expand executive power, end racial preferences, speed executions, welcome religion into the public sphere, and above all, reverse Roe against Wade, including guidelines advocating tightened standing principles, even when jurisdiction is authorized by the United States Congress. If these verdicts are overstated, which they could be, a recent empirical study of Supreme Court decisions from 1986 to 2004 by Professors Lindquist, Smith, and Cross, finding that judicial restraint has been contingent on the source of law at issue, is likely not overstated. 2 decades of cases, they conclude, demonstrate not judicial restraint, but commitment to a particular understanding of the Constitution, in which both states and the executive branch, but not the Congress, enjoy relatively great autonomy from legal restrictions. These studies measure, of course, the work of the Roberts Court's predecessor. But few would doubt that the present configuration of conservative judges, if bolstered by new additions, would seek to take us at least this far. If it is true, as many have claimed, that we now have a Kennedy court rather than a Roberts one, that, as it's said, Roberts presides, but Kennedy pivots, the High Court of the next 10 years will likely reveal no dominant and overarching Roberts imprint. I would be less than candid to deny my contentment that this is so. But enough of prognostication. As Mr. Barra famously noted, predictions are difficult, especially about the future. And if the past calendar year has taught us anything at all, it is that we actually have no idea what is about to come down the pipe. If we did, I assume everyone in this room would have made a fortune last year selling the market short. But what of the present court's treatment of the mainstay of Article 3's case or controversy requirement, the demand for concrete, distinct, and palpable harm caused by the defendant and likely to be redressed by favorable determination? Well, here, surely, the Roberts Court's rulings are not radical and studied efforts at door closing. Hine, the last year's taxpayer standing case, to my surprise, didn't overrule Flast, even if it treated it rudely. There, Justice Alito said, simply put, we've been idiotic on this front for 40 years, and idiotic we tend to remain. A little like my teenage daughter saying, you're no stupider, Dad, than you always were. In at least 2 decisions, the court has oddly welcomed suits brought by states, which would, we assume, otherwise perhaps have been cast out as exercises of general whining. And Massachusetts against EPA held that the extraordinarily widespread nature of harm from global warming, quote, presents no insuperable jurisdictional obstacle, and that a litigant to whom Congress has accorded a procedural right of intervention can assert that right without meeting all of the normal standards for redressability and immediacy, proving once again that a case or two notwithstanding, the justices will treat environmental disputes more generously than any other line of federal cases, except perhaps actions brought to challenge the use of race in drawing electoral districts. No wonder Justices Roberts and Scalia sounded furious. Rather than weigh in the pros and cons of these forays and the shifting and transient majorities that have produced them, I want in my concluding half here to return to fundamentals of Article 3, to the validity, the sensibility, the comprehensibility, and I suppose the legitimacy of the court's constitutionally rooted injury requirement. I am not as big a fan as some. And as I was thinking about how to get at that, how to draw out the point, it occurred to me that I have one means that perhaps belongs to none other. You never know what will happen in this life. About 15 years ago, I did another lecture, not unlike this one, at a distinguished law school set up by a noted law review, dealing with federal standing questions, followed by a learned panel of commentators explaining, as is the tradition, that I had no idea what I was talking about, and all subsequently published in an accomplished law review. With no offense to anyone, or apologies for my own poor memory, suffice to say that until 3 or 4 years ago, I had forgotten the entire transaction. That is, until John Roberts got nominated to be Chief Justice of the United States, and my phone started ringing incessantly. The soon-to-be chief had apparently been one of the commentators, and his article, or as he referred to it in his hearings, his little article, was one of the few published records of his legal thought. So it was briefly explored much more wildly than any law review article has an inherent right to expect. Apparently, all that could be conclusively proved before Roberts took the highest judicial seat on the planet was that he didn't think much of my jurisdictional theories. When all this transpired, I was a new university president who was already struggling with a political issue or two. Struggles that any aficionado among you could report, upon which I didn't ultimately prevail. So I repeatedly said to the press only something that was undoubtedly true. If John Roberts was critical of my standing theories, that lands him soundly and irrefutably in the legal and academic mainstream. I mention all this only to focus on Roberts' conclusion as an advocate in this piece for a tightened case or controversy requirement, even in the face of congressional acts to the contrary. Standing's injury requirement, Roberts wrote, is an apolitical limitation on judicial power. It restricts the right of conservative public interest groups to challenge liberal agency actions, just as it restricts the right of liberal public interest groups to challenge conservative agency action. The assumption that it cloaks a political agenda is facile. This enthusiasm for a vigorously implemented injury standard is apparent as well in Chief Justice Roberts' forceful opinions in Daimler Chrysler against Cuneo, Massachusetts against EPA, and Sprint Communications against APCC Services. I conclude by expressing, perhaps unsurprisingly, my modest disagreement with some of it. I don't mean just that the court's use of injury is often non-neutral in the crassest political sense, like when judges, liberal and conservative, simply switch positions, abandoning their traditional colors to suit the day, like a jockey deciding to ride temporarily for another owner, or Brett Favre donning a Jets uniform. As in Elk Grove against Newdow, the Pledge of Allegiance case, where Justices Rehnquist, O'Connor, and Thomas proposed novel door-opening theories, and Justice Stevens, writing for the liberals in majority, employed an entirely new theory of prudential judicial restraint. Or the similar flop that occurred in the Gratz case, or in Shaw against Reno, or when we see Justice Scalia advocate the broadest possible reading of the zone of interest test, and then enthuse in Bennett against Sphere over enforcement by so-called private attorneys general of environmental claims in which all have a common interest, leading my federal court students to wonder whether their book contained a rather embarrassing misprint. That is, until they read the facts of the case more fully. This sort of manipulation is simply the Bush against Gore shuffle. Any legal standard, with even the tiniest imprecision, is subject to its variations. And 200 years into the venture, to understate, we have not been able to render the definition of a case or controversy precise. Nor has the injury standard managed to avoid repeated applications that employ controverted, non-neutral, and unexplained visions of the reach, status, and enforceability of constitutional provisions. FCC against Akins, for example, appears a simple case to most members of the court. There, voters who were opposed to policies advocated by AIPAC challenged the Federal Election Commission's refusal to require disclosure of AIPAC's membership records under the FECA. Even when large numbers of Americans suffer alike, the court wrote, the inability to obtain information that the statute arguably requires be made public constitutes injury in fact. Of course, United States against Richardson has, for decades, stood testament to the fact that an analogous provision of the Constitution, the Accounts Clause, provides no such legally cognizable interest, leaving the odd result, though an oddity to which we have become accustomed, that if a widely shared interest is seen as so compelling that it is written into the text of the Constitution, it provides less litigating oomph than a similarly generalized statutory interest, or even an apparently commonly accepted social value, like an interest in the plight of the snail darter. Hine can be seen in this way as well. The case had its complications. The unexplainable distinction between executive and legislative expenditures, the open embrace of laundering of funds to avoid the strictures of the First Amendment, the beyond wooden reading of the court's jurisdictional rules, the fact that three distinct groups of justices could call one another disparaging names and all be correct. But its individual injury only reading of the Establishment Clause is hard to square, as Chip Lupu and Robert Tuttle have argued, with the limited government, restricted sphere, bounded separationist designs of the First Amendment, or with what even Chief Justice Roberts has ruled, the Madisonian right not to contribute even 3 pence for the support of any one religious establishment. It's unsurprising, perhaps, that a few months ago, the full panel of the Fifth Circuit would read Hine as blocking standing in an action challenging prayers conducted at a local school board meeting. Concurring Judge DeMoss wrote that mere exposure to government-sponsored prayer inflicts no greater injury on the observer than does a taxpayer's forced contribution. Injury may be swell, but with so little textual grounding and so much mystery of definition, it is difficult to see why it should limit or trump various constitutional interests of far clearer pedigree. But the toughest medicine of the injury requirement is not its theoretical justification, but its practical implementation. I wouldn't perhaps agree with every word of Justice Scalia's zesty opinion in Hine, but he is surely right in fleshing out his proffered distinction between wallet injuries and psychic ones to say this: the basic flaw in our cases is twofold. We have never explained why psychic injury was insufficient in the cases in which standing was denied, and we have never explained why psychic injury however limited, is cognizable under Article 3 in the cases in which standing was granted. Well said. Why plaintiffs challenging racially crafted electoral districts need prove no vote dilution, no hampered ability of representational capacity, no hampered ability to aggregate votes with like-minded citizens. It is enough, apparently, to assert that a constitutionally questionable practice sends abroad an unfortunate message, a theory regularly rejected on other fronts. Or why plaintiffs attacking affirmative action programs can escape the usual obligations of showing that they actually lost something concrete, like a contract or a job or a seat in a medical school class, as a consequence of the purportedly illegal practices. They, quote, need not allege that they would have obtained the benefit but for the barrier challenged. According to the justices, the, quote, tension resulting from traditional standing decisions like Worth against Selden and Allen against Wright is, quote, minimal, saying implicitly that the white challengers may not have suffered injury, but they came close. Standing law's special treatment program for those challenging special treatment programs. Compare these rulings with decisions like Lewis against Casey, where the court held that a petitioner denied access to prison library materials in violation of the right explicitly declared in Bounds against Smith, asserts no concrete injury unless he can demonstrate that the materials would have yielded claims apt to overturn his conviction. The opinion calls to mind images about carts preceding horses. And I don't know what the parallel would be in an affirmative action admissions case. Perhaps the petitioner would have to prove not only that he'd actually been admitted to law school, but he would have passed the bar and landed a job. We have never explained, as Justice Scalia put it in Hine, pro or con. The Article 3 cases attempt, first, to make the injury test operate with a precision and a solidity it likely cannot sustain. They then compound the challenge by failing to offer comprehensible justifications for the choices they make. The bolstered standing requirement becomes an opaque labeling exercise, often employed as a surrogate for larger currents of federalism, currents of separation of powers, or an unbounded urge to reach the case on the merits, either to embrace its theories or to bury them. A rule of concrete, palpable, rugged, durable, redressable harm that embraces an intensely subjective and yet non-personalized concern over the racial aesthetics of voting district lines, a shared apprehension over congressional expenditures that aid religious groups, an apparently individuated or representational interest in the impacts of global warming, the generalized benefits of living in a racially and ethnically integrated community, personal annoyance over the structuring of a government bidding process, even if one would never have secured a contract, and the borrowed interest in representing a class, even after one's own dispute has been rendered moot. These constitute clear injury on the one hand. On the other, the standard that summarily rejects an action based on the palpable fear of a second choking by the LAPD or judicially assumed and likely instances of exclusionary zoning or challenges to religious spending by the executive branch and analogous compliance claims under the Commerce Clause and the Elections Clause and the Accounts Clause and the Incompatibility Clause. This vision of durable harm is interesting and mysterious and unexplained and unexplainable. And contrary to Chief Justice Roberts' hopes, it is not neutral, an apolitical limitation on judicial power. The ability to pick and choose entry points with such discretion aggrandizes judicial authority. It does not diminish it. It is also odd, of course, to attempt to enforce such a meandering slalom on the United States Congress. One would think that a well-earned modesty would bar the justices from exporting their injury work product to direct collisions with co-equal branches of government. And the fluttering nature of injury surely makes discussions of Article III originalism at best quaint. I remain one who believes with the historians that the common law backdrop of the case or controversy requirement allowed the presentation of actions without demonstrable personal injury. But even if that's not so, the harm suffered to my representational prowess by being only 96% of that of my colleagues in the next electoral district, I'm guessing would be well beyond anyone's notion of litigational triggering in 1789, to the extent that we can actually identify notions of litigational triggering in 1789. I close only by adding there is perhaps one thing worse than a legal standard so thin, so conclusory, that it can't do the work for which it was advertised. And that is, if it seems in operation more frequently to aid the powerful and hinder the powerless. I know it's possible to see the United States Supreme Court standing decisions of the past 2.5 decades from many different lights. But surely one of them is that what has been made demonstrably easier for those who would challenge efforts to increase minority voting representation or minority access to higher education or to professional schools or to government contracting. That has been made decidedly more difficult. That has been made decidedly easier. What has been made more difficult are such attacks for those seeking to challenge government decisions that burden the economically marginalized, or that support private racial discrimination, or that limit the availability of essential social services, or contest brutal law enforcement practices, or that challenge the preferences offered to dominant religions. In a society still the richest on earth, the richest in human history, but where 1 in 5 children lives in stark, unrelenting poverty, where we can boast, if that is the word, the largest gaps between rich and poor in the industrial world, where we spend more on health care than any other nation, but leave dramatically more of our fellows outside the system, in the shadows, where a huge cut of the populace is flatly priced out of the voluntary use of the civil justice system, where we have as yet rich and poor public schools, not just private ones, where access to higher education remains so closely linked to family income, and where the political system itself is perennially skewed towards the interests of the wealthy. I would be loath to add yet one more regime that, even if indirectly, favors the powerful and chides the powerless. In the world's greatest democracy, we've got enough of that already. Thank you very much. Any questions? Yes, sir.
In the interest of full disclosure, I was the other lawyer on Bowles v. Russell.
Well, I think that you ought to be able to stand up and make your peace, it seems to me. So you were the non-Kafkaesque counsel?
That's right.
Weren't you stunned by the brutality of your opponent? His heartlessness?
Probably in his heart, he was on my side.
That's what he told me, but it's sort of hard to believe, isn't it? That's it. Nice to meet you. Well, all right. I won't beg. But we have a standing panel coming up in just a minute, all right? Thank you very much. It's been great to be here.